Welcome to Q&A, Social Security Disability Today. This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves. Here's your host, attorney Anthony Reeves.
For those of you out there who are actually applying for Social Security disability benefits after April 20th, 2015, you need to be aware that there's been a recent change in the regulations with regards to evidence. Now, most of you are not going to probably know about this primarily because of the fact that, you're applying, you're not thinking about anything in particular. I'm not sure what the local Social Security offices have told you, and if you've had, and more importantly, if some odd reason you've already applied, I don't know if any of you have gotten any notices in the mail about the recent change. But if you haven't, let me share with you some information. Social Security recently on April 20th, 2015 has instituted what we call the all evidence rule, which basically says that when you're applying for disability benefits, you must submit all evidence in its entirety or make Social Security aware of all evidence in its entirety about medical evidence that relates to your claim for disability benefits. That's just a nice way of saying if there is medical records out there, and this is where you need to keep it in mind. If there are medical records out there that relate to your claim for disability benefits, meaning if you say you became disabled because of this condition, if there are medical records out there, you have a responsibility to not only get those records, but make Social Security aware of those records in the event you have difficulties in getting those records. This is an important change, and the reason why it's important is, and this comes up a little bit more so, is that before April 20th, you've heard me say a million times that you bear the burden of proving that you're disabled. Part of the problem is that some people, not everybody, but some people have taken that to mean to only provide that evidence that helps their case because they're trying to prove they're disabled. So a lot of times what people will do is they'll only submit that evidence that they believe will be helpful for their case. Under the new regulations, you need to submit it all, good, bad, or indifferent. If you've got evidence out there that relates to your condition, you have a responsibility to let Social Security know about it, as well as getting that information. Now, I'm going to tell you this is going to be even more so crucial if you find yourself in a position where you're getting ready to go before an administrative law judge. Because remember, at the hearing level, the Social Security Administration typically does not get your medical records for you, except in instances where, of course, you bring that information to their attention. So that means if you've been denied in one of those states that has two levels of denials, meaning initial and a recon, or even one where it's just one initial denial, and you're going before a judge, it is very important that you take the opportunity to get a copy of your file and make sure that they have everything in it. And if it's not there, you need to either get it or bring that information to Social Security's attention. They're going to want to know who you've been going to see, how long you've been going to see them, what have they been treating you for, and the reason how they relate to your condition. All that information is very important. The reason why is because, like I said before, there has been individuals in the past who have utilized this whole duty to prove you're disabled as an opportunity to only submit what they consider to be good evidence in their behalf. So you tend not to tell about the bad one. You can't do that now, because that actually may hurt you